Hello everyone, welcome to our channel. This is a Posh at Work presentation of legal insights on important issues surrounding sexual harassment and related matters. Posh at Work is a boutique firm which assists organizations across sectors in complying with the law against sexual harassment at workplace and related matters pan-India. My name is Sania Talwar. The judgment I will be discussing with you today is Vijay Kumaran CPV versus Central University of Kerala and others by the Supreme Court of India on 28 January 2020. In a nutshell, the Supreme Court held that since the report of internal committee confirming allegations of sexual harassment as per Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 against Vijay Kumaran formed basis of his termination, the order of termination was stigmatic and therefore Central University of Kerala should do further inquiry against Vijay Kumaran as per service rules before terminating him. The background in this matter is Mr. Vijay Kumaran CPV was appointed as Associate Professor of Central University of Kerala in 2017. His letter of appointment stated that he shall be governed by the university's rules and regulations, orders issued by the University Grants Commission and Government of India, and the Code of Conduct applicable to all employees. In July 2017, a complaint of sexual harassment was filed against him, followed by two more complaints filed by 16 students and 23 students respectively. Accordingly, an internal committee was constituted to look into the complaints as per Section 4 of the law of the committee. The committee in its report found Vijay Kumaran guilty. Committees are required to make a report regarding the inquiries they conduct as per Section 13 of the law. The committee submitted their report and recommended that Vijay Kumaran should not be allowed to engage the classes and evaluation duties, and Executive Council should take further action as per service rules. The Executive Council passed an order in November of 2017 terminating Vijay Kumaran. Now, Vijay Kumaran reached out to the High Court of Kerala at Ernakulam and said that the termination order of November 2017 was stigmatic. The High Court dismissed his contentions. Therefore, eventually, Vijay Kumaran approached the Supreme Court and is called the appellant in this matter. As a result, the questions before Supreme Court were as follows. Number one, whether the termination order was stigmatic, and number two, whether termination was valid. On the first question of whether the termination order was stigmatic, the Supreme Court observed that the opening part of the termination order mentioned that on scrutiny of the internal committee's report, other documents and academic performance, the Executive Council of Central University of Kerala in its meeting held on 30th November 2017 decided to terminate the services of the appellant. In this regard, the Supreme Court held that number one, the termination order cannot be considered a simple order of termination because it had made the report of the inquiry conducted by the internal committee and the decision of the Executive Council as the foundation of termination. Secondly, even Executive Council, while taking the decision, had in turn highlighted the fact that appellant had to face an inquiry before the internal committee. Third, if it had been a case of mere unsatisfactory academic performance, the situation would have been entirely different. So, to clarify why the termination order was not simple but was stigmatic, court said that the material which amounts to stigma need not necessarily be contained in the order of a termination, but may be contained in any other document referred to in the termination order or in its annexures. In that case, such an annexure or document can be called for by any future employer. On the second question of whether the termination was valid, the Supreme Court held that it was not valid. It said that it is not advisable to give benefit to an employee by merely passing a simple order of termination if there is an allegation of sexual harassment, defined in Section 2N, read with Section 3 of the 2013 Act, and a serious matter bordering on criminality. It said that such complaints should be taken to their logical end by not only initiating departmental or regular inquiry as per the service rules, but also followed by other actions as per law. In such cases, it said that a regular inquiry or a departmental action such as per service rules is indispensable to enable the concerned employee to vindicate their position and establish their innocence. In our view, it is absolutely correct that parties should be given an equal opportunity to be heard and defend their case. There have been several cases in the past that explain that the right to examine and cross-examine should be given by IC to parties so that they get opportunity to be heard and defend themselves. The law also states that the IC has to do the inquiry as per service rules wherever applicable. However, there have been some judgments in the past that state that findings of the committees are binding on the employer and employer can directly proceed to take action on the basis of internal committee's findings. For example, the Supreme Court in Medha Kotwal Lele judgment held that the report of the complaints committee can be treated as a finding of guilt for imposing penalty. The High Court of Guwahati in the Tezpur University case said that inquiry report of the internal committee was sufficient to impose penalty and that subsequent inquiry proceeding by appointing an inquiry officer was unnecessary. Another judgment, the High Court of Calcutta passed in the Pradeep Mandal case, which said that the scheme of the 2013 Act gives a somewhat exalted status to an inquiry report than an ordinary inquiry report would command, and findings of the committee is binding on the employer and cannot be tinkered with by the employer. Hence, keeping in mind the law and all the above judgments, it is unclear how further inquiry as per service rules is held by the Supreme Court in this case is to be conducted. Who should be conducting it? What is the value of internal committees, inquiry and report in such cases? Whether witnesses and parties would be required to be called again? Whether committee's report will be referred to? Whether its findings will be binding, etc. Unfortunately, the Supreme Court has not made any comments or observations on these aspects in this judgment. If you found this information helpful, please like our video and subscribe to our channel for regular updates. In case you have any queries about the law or our services or want any assistance, please visit our official website www.poshatwork.com or contact us. All links and other details are provided in the description below.